Good afternoon. Today I'll be discussing the implementation of a mandatory disclosure requirement for Indigenous traditional knowledge into Australian patent legislation. The current Australian legal patent system does not acknowledge the Indigenous and is not sui generis, meaning specific, nuanced or adaptive enough to protect and/or manage the rights, knowledge, land and culture of the Aboriginal and Torres Strait Islanders. The current legislation does not specifically mandate a disclosure requirement for patents. However, it does outline effective protection of intellectual property IP. Any implementation of a disclosure obligation should be carefully formulated to align with the broader objectives of the Trade Aspects of Intellectual Property Agreement, TRIPS, and we should look upon New Zealand as a legislative role model. The IP Australian Consultation Report provides a clear and specific outline for implementing a disclosure requirement for patent applicants. It clearly distinguishes between the traditional world and the Western world, as indicated in this figure. This is fundamental because they are two separate worlds, and therefore traditional knowledge requires a standalone legislation scheme with a legislative balance. Traditional worlds is law, spiritual beliefs and customs, concerns and respect for elders, communal ownership. The Western world is formulated by legal systems, political systems, and individual ownership. We must ensure that we protect the Indigenous by obtaining a balance between the benefits to society and commercial exploitation, as indicated in this next slide. Does the detriment of Indigenous exploitation outweigh the benefits to society? Health benefits to the public, life-saving pharmaceuticals derived from TK knowledge, versus commercial exploitation of Indigenous traditional knowledge. Does the detriment of Indigenous exploitation outweigh the benefits to society? We must also consider all stakeholders, as indicated here. The report confirmed that stakeholders support the initiative, but we did not outline the importance of stakeholders, which is imperative when ascertaining how to implement an Indigenous disclosure requirement. This would enhance the efficiency of the report. Stakeholders like businesses, sick patients waiting for life-saving medical treatments, inventors, and Aboriginal and Torres Strait Islanders. So let's start with Aboriginal and Torres Strait Islanders. Aboriginal and Torres Strait Islanders have an individual connection with traditional knowledge and genetic resources because they inhabited Australia first. Quantitatively, they have the longest history stakehold, and qualitatively, they have the strongest, most sacred stakehold to the land, as indicated in this image. Any disclosure amendments to patent legislation should contemplate the preservation and protection of biological resources and traditional knowledge. Implementing a disclosure requirement would protect against the stealing of traditional knowledge by making it mandatory to expose the original source of inventions. It is also critical to guarantee that the rights and interests of Indigenous communities are safeguarded whilst involving them in decision-making processes concerning the use of their traditional knowledge. The Mary Kay is a well-referred-to case by the Indigenous as lacking novelty because it was used without disclosure, acknowledgement and benefit sharing, and the company withdrew the patent application in Australia. Despite being predominantly viewed by the Indigenous as a way for third parties to commercialise their traditional knowledge, Australia, like New Zealand, should be more innovative with its IP laws to ensure they address the concerns of the Indigenous people before they exploit their traditional knowledge. Patenting is aligned with private economic rights, whereas Indigenous rights are collectively based and in line with our obligations and respect for natural resources. This collective right equates life-saving medicinal purposes more accurately than private rights do, and the businesses should definitely focus on this aspect. So moving to the next stakeholder now, businesses. Businesses, predominantly those involved in research and innovations, have concerns about the impact of disclosure on their ability to protect their inventions whilst preserving a competitive edge. They argue that obligatory disclosure results in revealing valuable data and statistics would, for intellectual property, making it easier for opponents to duplicate their innovations. Balancing disclosure with the protection of proprietary information is essential for addressing these concerns. But the complexity of the issue must be emphasised. Unlike copyright law, patent law does not have an exception for fair use, and the rampant patenting of genes and DNA fragments has led to the tragedy of the anti-commons, which is the effect of an overabundance of private property rights has on the use of property. Please refer to this image now for an example of cDNA, which demonstrates the cost of disclosing and patenting hundreds of cDNA fragments, as here, for a single therapy is very high, and its commercial exploitation should only be considered after the disclosure of its original genetic resource and after it saved a life. For TRIPS to effectively implement a disclosure requirement, there needs to be a clear distinction between disclosing the original genetic resource whilst protecting the Indigenous from commercial exploitation. There should be a hierarchy established to ensure that the disclosure is for respecting our Indigenous and saving lives, not illegally stealing their knowledge for commercial exploitation, as indicated in this image. If a patient's going to die, a hierarchy must be established. Is disclosing the original genetic resource and saving the patient's life more important than patenting it for commercial gain? I think so. That's why at the bottom of this stakeholder hierarchy, as the most important because it holds the rest of the triangle up, we have acknowledging Aboriginal and Torres Strait Islanders by disclosing original genetic resources for the goal of saving lives and benefiting society as a whole. It's a public interest, not a private economic benefit, for things like critically ill patients and the general population. In the middle then we have inventors for patent protection, which discloses original resources whilst preventing theft and/or unlawful use of their knowledge. And at the top we've got businesses, whilst ensuring fair dollars for everybody involved. It's also important that we protect the ideas of inventors who have used Indigenous resources as a springboard for their own inventions by preventing theft and/or unlawful use. From an inventor's standpoint, mandatory unveiling could motivate their decision to pursue patent protection. Some inventors may be concerned that exposing their ideas would leave them open to idea theft and/or unlawful use. It's important to analyse the impact on inventors to navigate sophisticated patent systems. This complexity derives from efficient collaboration and consultation with all parties involved. Collaboration and consultation. For an effective implementation of disclosure, it is essential to engage with Indigenous communities to comprehend their traditional knowledge, IP perspectives, and cultural practice. Further, their input should be considered. How would they like their traditional knowledge to be protected? And how would they like to be included in the patenting process? This can only be done by establishing clear guidelines. Developing strong regulations or guidelines that require patent applicants to unveil any use of traditional knowledge would be effective. This should outline the process of recognising and gaining consent from relevant Indigenous communities. These guidelines should be sui generis, specific, as we've spoken about earlier, and adaptive to Indigenous beliefs. Some examples now of how we can adapt our legislation to those of the Indigenous. Pharmaceutical substances have a patent term sometimes of up to 25 years. This is not consistent with Indigenous customs because traditional knowledge has no expiry date and is passed on from generation to generation as sacred knowledge, just like the roots of a tree, as indicated in this image. Further, secrecy is sometimes paramount, as per the case of Foster v Mountford, and traditional knowledge may be sacred and not suitable for wider circulation. Therefore, disclosure must be formulated in such a way that if secrecy is required, it is still lawful. It's baffling that Indigenous disclosure hasn't been implemented yet, because for an invention to be patentable, there must be an inventive step. And this can't be considered without considering the prior art, as per the case of Park Davis. This prior art disclosure and prior informed consent should be mandatory. So let me explain this here. We've got Indigenous traditional knowledge in the trees, Indigenous traditional knowledge in the grass, Indigenous traditional knowledge in the roots of this tree. Okay, now for an inventive step, essential oils from various native Australian plants, including those commonly referred to as the tea tree, had to have been extracted and used for claimed medical purposes. We are however forgetting that the evidence also indicates a very long history of Australian Aboriginal people having used this first. Therefore, in order to establish this inventive step, we must disclose that we found this via traditional knowledge first. This is what's led to us inventing things like the Thursday plantation tea tree oil and antiseptic, as we see in so many pharmacies everywhere. So this leads me to prior informed consent. The report mentioned consent, but didn't elaborate the importance of prior informed consent specifically. Patent applicants must establish that they have gained prior informed consent from Indigenous communities before using their TK in patentable inventions. The consent should be obtained through a procedure that is culturally respectful and suitable to the rights of the Indigenous. In the case of Moore versus Regents, the patient suffered from leukemia, and before advising Moore that he needed to have his spleen removed, the physician decided he would use it for research purposes. Moore sued, alleging he was unable to make an informed decision, and the court agreed, concluding that a physician must disclose personal interests unrelated to the patient's health, whether research or economics, that may affect their professional judgment. Patent applicants must disclose that they have obtained biological resources, not only out of respect to the Indigenous, but also as a safety precaution because the resources they are using for their inventions might affect their professional judgment. In the case of Greenberg versus Miami, a researcher patented the genetic sequence of Canavan disease after studying blood and tissue samples of several donors without disclosing his economic intentions to commercialise from it. The court rejected claims on the ground that it applied to physicians and patients, but not researchers and donors. This takes the narrow informed consent further because it demonstrates how donors who intend to contribute to the public domain can be misled by researchers and left without remedy. For years we have stolen from the Indigenous who did not voluntarily consent to us using their knowledge, and they have been left without a reward and a remedy. The Indigenous case of Jabree versus Gold Coast caused a laughingstock amongst the younger Bear people. Pardon me if I didn't pronounce that right. Because it represented them losing control of their culture and heritage. Although we can never remedy the laughingstock we have caused, the resources and the land we have stolen, we can prevent this from happening again with the solution of benefit sharing mechanisms. Creating mechanisms for guaranteeing that Indigenous communities benefit from the commercialisation of patented inventions that include their traditional knowledge. This involves income sharing, technology transfer of other forms of mutually agreed benefit sharing. The Gumby Gumby case evidenced that IP laws can prevent non-Indigenous companies from inauthentic marketing and instead reward Indigenous producers with a fair economic return. Further, we should establish specialised review and examination processes within the Patent Office to evaluate the disclosure and usage of traditional knowledge in patent applications. This involves the inclusion of traditional knowledge, expert knowledge, and cultural practices in the examination process, and this would educate all parties involved. This could be achieved by providing training, education and awareness as indicated in the report, educating attorneys, patent examiners and inventors on the importance of respecting traditional knowledge and the legal requirements for its disclosure in patent applications should be mandatory and more tools required for this in layman terms as indicated in this image. This education in layman terms should extend to the implementation of a standalone legislation which provides an overarching framework that ties into the patchwork of existing laws to provide better protection for traditional knowledge, whilst ensuring that it is compliant with the TRIPS agreement. So moving along to the TRIPS agreement now, Article 27. The disclosure of biological resources is imperative if we are to establish an inventive step, as per Article 27.1 of TRIPS. This emphasises the urgency for a legislative reform making disclosure mandatory, as it would only enhance the efficiency of identifying an inventive step. In the case of Park Davis and Co. versus H.K. Malford, the invention was patentable because although the adrenaline salt occurred in nature, the animal here, the process of removing salt from the gland tissue and being the first to make it available for use resulted in a new composition of the matter. This outlines the importance again of distinguishing between the disclosure of the original source and the inventive step. Further, Disclosure would be in compliance with order public or morality by preventing the commercial exploitation and protecting humans, animals, plant life and our health, and avoiding serious prejudice to the environment by proving that a lot of our most important biological resources actually derive from traditional knowledge. As per the case of Milpururu, it has been compulsory on Indigenous people seeking protection of cultural property interests to prove original interpretations of pre-existing traditional designs. Further, members may also exclude from patentability diagnostic, therapeutic and surgical methods for treatments of humans and animals as outlined, and the biological and microbiological processes stipulated by the implementation of an effective sui generis specific system which has been outlined in the report and discussed in this speech. These examples indicate that disclosure is consistent with TRIPS, but there is still a need for specific standalone legislative reform which addresses the specifics of disclosure and Indigenous TK. So now we're going to look at the proposed Article 29 bis of TRIPS. Opponents contest that mandatory disclosure requirements would impose substantive patent requirements over and above those set out in Article 27 of the TRIPS agreement. In response to this inconsistency, an amendment by like-minded countries around the world was proposed with a revised Article 29 bis, disclosure of origin of genetic resources and/or associated traditional knowledge, where if the subject matter of the patent involves the use of a genetic resource and/or associated traditional knowledge, you must disclose it. The proposed consequences for failing to comply would include administrative sanctions, criminal sanctions, fines, compensation for damages, or revocation of the patent altogether. This proposed amendment would be a specific legislative solution which would coincide with the proposed consultation report and emphasise its importance by penalising those who do not comply. To conclude, the differences between the Western and traditional world are warrant for a specific standalone legislative reform. The Australian consultation report is effective, but it doesn't necessarily address the complexities by evidence of scientific facts or case law. The disclosure requirement under Australian patent legislation would be consistent with the obligations under the TRIPS agreement if Article 29 bis was implemented, which specifically addresses disclosure requirements and Indigenous patent protection. Further, intense education is required to fully comprehend the complexities and nuances of Indigenous and patent relations, and this should be better articulated in the report. Thank you.